And if Madam First VP, if you can go ahead and pray us in.
Okay. Dear God, we thank you for this day. We thank you, dear God, for allowing the women of God to come together in this sacred space, dear God, to be able to share knowledge, dear God, and to glean knowledge from those you've entrusted it with. We pray, dear God, that you would be honored and blessed with all the things that go on in this circle. And we pray to God that we can do for as many as we can, for as long as we can, the best way we can, while we can. God, we thank you. And we know, dear God, that you have blessed the speakers this morning, and God, we pray to God that they will be able to impart the knowledge that you've given them to us, that we may go, dear God, and do better for our people. In Jesus' name we pray. Amen.
Amen. Thank you so much for that. And I would like to welcome you all to our financial literacy summit today. I am your 2022 Women's Council of National Association of Real Estate Brokers, Memphis Chapter President, Kay Thompson. And today's topic that we will be discussing is selling your inherited home. And I am so honored to be a part of what I know is going to be an enlightening and just dynamic conversation between two fantastic people who really know their stuff. So I am honored to introduce to you our Madam Governor of the Memphis chapter. She also heads up our national education team with the Women's Council of the National Association of Real Estate Brokers. She is a real estate instructor. She is a real estate broker. So she has her hands in pretty much every aspect of real estate that I can think of. That is our very own Miss Nedra Redditt. Welcome, Madam Governor.
Thank you. Thank you. Thank you. Thank you.
Yes. And next we have our fantastic and awesome parliamentarian. Her name is Miss April Bostic. She is an attorney working with us to help us to understand just what it means to sell an inherited home. She does a lot of work for us on the back end. She keeps us legal, and we're happy to have her mind here with us today too.
Thank you.
Yeah, so I would like to start by asking Madam Governor, why is it important that we understand the nuances that go into selling an inherited home?
Thank you, Madam President. And that is a very, very important question in our community anywhere in America. We have the same challenge. There's a lot of our parents, grandparents, and great-grandparents that really worked hard and acquired and maintained real estate. And unfortunately, upon their demise, when they passed away, they left it to individuals who just may not have known what to do to maintain those properties. And so in our effort with the National Association of Real Estate Brokers, we're trying to increase home ownership and wealth through the use of home ownership. One of the ways we found, one of the leaks in the can that we're trying to fulfill is that we believe that if people are going to be nice enough to leave us something, we ought to at least know how to maintain it, what to do with it, and not to just give it away, you know?
Yes.
Even if we personally didn't want it, we should know some alternatives to passing it on to others. And so that conversation has been going on for many, many years. And Petrella and I decided we were going to do something about it and put it into practice, write a book, and that's what we did.
Great, that's wonderful. I think it's important to note that probably some of the blight that we experience in our communities is a result of people partially not knowing what to do with homes that are inherited.
That is absolutely a correct statement. Exactly, because most people, even if the property was given to them, the first thing they want to think about is, well, it's going to cost me something. And many times they don't know what this something is. Many times they don't know the tools and have the resources. There's just a lot of challenges in our community. And so our thoughts were we would do these events every quarter, if possible, to make sure that our community understands that while they themselves, who were the recipients of this real estate and many times personal property as well, that they don't necessarily just need to let it sit there and deteriorate. That there are people and resources in place that they can get with individual people so that we can show them how, while they themselves don't know what to do, there are those of us who do. And so I'm just so excited to be able to speak on this subject today. And I'm just so excited that Attorney Bostick is going to be here to answer all of the legal questions. We're going to stay in our lane as real estate professionals, and we've got attorneys on hand. And I think she even got a judge on speed dial. And we're just so excited. We're just excited about this event today.
Well, great. So I want everybody to sit back and tune in. We have a wonderful presentation. I do encourage everyone to ask questions because everyone has someone in their circle or will have someone in their life that is going to need to know this information. And so often in our communities, we are reacting. We are reacting to the situation. We are reacting to, circumstance and events. And so this is something that can really set your entire family up to maintain that generational wealth that we are working to build. Because I'm sure Attorney Bostick has probably heard of or seen in her career where people lose homes that are inherited because they don't have an understanding of the legalities that surround it and their rights as it pertains to it. Would you say that's true, Ms. Bostick, attorney?
Very, very true. That's a very true statement.
How much of that do you think we are seeing in our local community? Like, how often do you see people who have questions about what to do with the home, or even disputes within the family that come up because they don't understand how inherited property works?
So a portion of my practice is in probate, estate planning, and real estate. So I see it from all sides. And the number one problem that my clients have when it comes to real estate issues are dealing with heir property. And I mean, it's it runs across the board. It's tax issues, it's issues with other heirs or family members, it's title issues. And a lot of times, unfortunately, they don't know what to do, and the property ends up going in a tax sale because either no one wants to take care of it, or they don't know the appropriate steps to even maybe put it for sale, and at least, get some type of income or wealth from the property. And so I think that education about heir property, what to do with it, what your rights are, and even how to resolve problems is something that's much needed in our community.
Right, exactly. So that is why this topic of conversation is so important today, because this is just one of the many things that your Women Council does to make sure that we are, empowering our community and that we're building them up. This is something you need to know to keep your wealth. Keep it with your children, keep it with their children, and so forth and so on. And so without further ado, our wonderful Madam Governor has a fabulous presentation that she wants to share with us. So I'm going to yield the floor to her. And remember, guys, make sure to ask your questions, put those in the comments section. We do want to be mindful of everyone's time, and we want to keep it all organized. And that is the best way for you to get the information that you seek. So without further ado, Madam Governor, take it away.
Thank you, Madam President. And today I want you to know I must do a disclaimer. We do not, Attorney Bostick and I had a conversation. We do not expect you to leave here thinking you know everything, because we're not even talking about everything. We're just beginning the tip of the iceberg, if you will. We're just gonna scratch the surface. We just want you to start thinking about it. And then that's why I know that Attorney Bostick is gonna do some specific estate planning events later, and we're gonna keep this conversation going, because we said if we were to teach this every day in our community, we still would have people who would know what we were talking about. So I just want to be really clear about that. This is not a situation where you're going to learn everything today, but we certainly can start raising your consciousness of this discussion. And I thank you all, Women Council, for allowing us to bring you this subject.
We thank you for being here with us.
So again, what made me think of, oh, we need to do this event really quick is because we released this book, Tips and Tricks, on how you sell a house. Now, obviously, we talk to a lot of lawyers in our community, title companies and all of those folks, and they're the ones that's helping us, because we've helped a lot of attorneys with real estate transactions in our career. That's what made us focus on this particular area. We've helped a lot of families in this community sell property who were benefactors of real estate because mama and daddy passed. It could have been mama, dad, and daddy had already passed. It could have been that the property was in a state. It just all across the board. And so we, Fitzgerald and I were talking about, we want to niche market something. What have we been doing that's just niche? And we said, of course, people then, nobody knows what to do with the property. And so what we'll do is we'll just get with someone to help us get the message out in a book. Now, we want to be real clear here that this is just, again, some of the basic information. We certainly don't want you to think that you're going to get everything that you ever want to know about this process, but we're going to certainly raise your consciousness. When we first ventured into the real estate industry years ago, we did it with the hopes of helping sellers to avoid those headaches that are often associated with the home selling process. So here's what we knew. We knew that most people, unfortunately, all of us are going to pass away. Okay, so that's just the truth. So we got all that, and a lot of times our truth is we don't want to talk about it. And so, we said we've got to have the conversation. So we'll be the ones in real estate to bring it up, and let's start putting this on the mass of our community. So over the years, a lot of years of experience of work with this group. Not only have we helped people to alleviate the stress of selling their home, but also we have those number of years where we have helped them get money out of their home when they come to us and said, Mom and Daddy died, and we know we're not going to get anything. That's kind of how they opened it up. And we're like, what do you mean? Well, they passed and the house is not worth nothing because it's got all these repairs and blah, blah, blah. And we're like, they need help. And so we decided we would share with them our expertise in this with these clients. And so we said, let's just write this book, and maybe if they see it in written form, we know in our community, if we see something in a book, even though we ain't gonna read the book, we're gonna read the title, and then we'll go, oh, it was in a book, so it must be true. Okay, so we approached it that way with the possibility of helping more customers. So we know that we want to help them get the most money out of their house by them selling their home in the least amount of time. But that's what's going on, because there's so many expenses and things on the table when someone passes away and leave you something. I mean, you just see headache after headache, and they're mad. Now, we know we're professionals, we don't see us headache, but they do. And so we have to make sure that we can streamline this so that they don't think it's going to be a headache situation. And so in talking about how we were going to help them accomplish this, of course, we wanted to talk about the secret strategies. One of the strategies of selling their home when mom and daddy passed away. And then we wanted to talk about some of the marketing techniques, because they're different than when you're selling just a regular normal sale. Okay. And the information that's going to be necessary for the professionals like the attorneys who's going to help ascertain the bottom line. What can they get? Is it a debt owed? And all of that, getting clear title, and just all those things that we know we needed to do. And so we just said, let's put together a presentation and try to help our community. Now, one thing we do want everyone on this call to know, and any of your friends that register, we want them to know that there's a way for them to get a ebook of this awesome tips and tricks on selling inherited home. We're going to be sending that out. Women Council is going to make that available to them at no cost. It's an ebook, and so we just want to show our appreciation for them signing up for this class. You know, when we are talking about dealing with an inherited home, there are a lot of issues that have to be addressed, and so it's a very complex subject. So, you know, we don't want to play down the importance of this subject because it's very, very important. A lot of complicated issues have to be resolved. I mean, I was involved in one transaction where it was like 28 heirs. I mean, literally 28 heirs involved. There's so many people involved that one would think, well, it's no sense in trying to sell it because there's too many people. Well, that's not a good attitude to have. And so we always want people to understand that where there's a will, there is a way. And so we went out and we searched. You asked the question earlier about inherited property. Well, we searched the word selling inherited property, and it turns out that there was more than 10 million results. We searched selling inherited property. It returned to us over 10 million results. So when you think about it, there are lots of individuals in the world. By the way, we're not just talking about Tennessee. Now, obviously, we're licensed in Tennessee and Mississippi, and Case, Tennessee, Mississippi, Arkansas, some other places, Attorney Bostick in several states. We can help people anywhere. So what we're trying to say is we can help anybody anywhere. We can send out referrals. So we want to make sure our people know that. There are questions about, is there going to be a capital gain tax on the property when you inherit it? And then, you know, the government does a good job of letting us.
Madam Governor, I texted her, guys. So. Well, until she comes back with us, I will go ahead and read the slide that she has up here. It says, dealing with an inherited home is a complex subject, and there are several complicated issues to resolve. A web search for selling inherited property returns more than 10 million results. A glance down the first page or two shows some of the following issues. Do you pay capital gains tax on property you inherit? Oh, her presentation went away. Let's see, but I have it, guys. Give me just a minute. Let me find it on my. Okay, got it. Up. There we go. Bear with me, guys. I'm almost. Hopefully, she'll come back into us very shortly. But I'm going to share my screen so that you can. All right, can everybody see that?
Yes.
I can see it. Mm-hmm.
Okay, good. Now I'm going to try to make this so that I don't hide the words. Okay. Archie Emerson is on. Okay, so what she was saying was that dealing with.
So with Broadview America, our goal is to also.
Here she is. Thank you.
Giving you guys a vision for what the city of Birmingham can be, and doing.
Can you all hear me?
Yes, we can hear you.
All right, very good. Don't know what happened with that, but that's the internet, and that's.
Can you still see your screen, Madam Governor? I went to share the.
I can, but I can share it again.
Yes.
No, it says you cannot share while the other participants share.
I just stopped.
Okay. And I will start.
Yes.
Where are you?
Technology at its best, folks.
Oh, yeah, absolutely. And we will have this up. Here we go. Let's go to the top. A slideshow on the current one. Okay. And at the end, let me go back to the beginning and we'll get you there because we were right about here. And we're talking, can you all see the slides?
No,
You can't see them? Okay, let me do,
No.
your
Yeah.
screen is not being shared right now.
okay, let me see if I can do that.
Yeah.
Open it
Okay. I just made you the co-host again there.
up. Okay,
So you should be able to share now.
okay, great. Tell me when you can see it.
We can see it.
Okay, perfect. All right, so here again, what we're talking about. Oh, hear me? You asked me to turn my volume up. I put it to 100. Can you hear me?
Okay,
Yeah.
yes, we can hear you pretty good now. It was just a little choppy before. So if you
Gotcha.
could go back just a few more, like just a, I don't know, maybe one paragraph up and one
Okay.
page up. Yes,
And
that's
right
what,
here.
yes.
Sure. Now, again, when we're dealing with inherited homes, if you're wondering what is that number out there, it's millions. Okay, so bottom line, it's millions. Also, our government, as you know, when you own a home and it's your primary resident, there is an exclusion for having to pay capital gain taxes on this sale. But if it's inherited property, you want to make sure you're talking to your local Tennessee tax accountant, someone who knows Tennessee law, and your attorney, so you can make sure you're in lockstep with that, because there will be some consequence if this is not your primary resident. We're going to talk about what do you do when you inherit your parents' homes and all of the other things that's involved. A lot of things. Again, as I said in the opening, we are going to be obviously we're going to give you as much information as we can in this area so that you can feel like you have at least a sense of where do I go next. Additionally, it's not uncommon for a person who is selling an inherited home to have those sentimental attachments to the property. We all get that. We have parents and siblings and things like that, and extended family members, aunts and uncles. And so we know when that death comes that there's going to be someone who's going to leave us real estate and, again, personal property, and it's going to have some sentimental value to one person, whereas another person just clearly see it as like the prodigal son, cash me out, give me mine so I can go. Okay, and so we want to make sure that there is a place for them to go to get their questions answered. We have an attorney part of this event, and I'm excited Attorney Bostick could be here. But because of the continuing property ownership, like things that are going to continue every 30 days. And you know this because if you live in a house as a tenant or you own property, you know these things are going to come every 30 days. Property taxes, insurance, utilities, maintenance, interior, exterior, ground maintenance, all those things are going to be necessary. And just because someone passed away and leave you the property, don't think that those things are going to automatically be done by some other person. So when you're getting a loved one's home ready for the market, you want to make sure that you have clarity about what is going to happen. You want to make it, just remove the stress and just try to work with that individual, because they don't know this. All they know is they just lost their loved one. Now they got to sit in the floor and go through these once treasured personality things, their belongings. They got to depersonalize the rooms. The rooms used to be, this was her favorite chair, all those things we go through with our loved ones. And so that's what you're dealing with, a lot of emotional stress. Then there's the financial costs. Of course, if you're gonna try to attract a buyer, it never fails me that people say, well, my aunt passed away and left me the house and I want to get as much as I can get. I said, well, that sounds good on the surface. So we need to talk about your options, because if you do everything you need to do to get it into that condition, on the top side, I always tell people it's 3 types of markets. It's the low, as is, where is, what is, and then you have the medium, and then you have the top side. So let's talk about which number makes sense to you based on what you're willing to do. So we got to talk about that. You know, does the systems work? Does the electrical work? Plumbing? Are there leads in the gutter? You walk up to the front door, does it look like nobody's been here in 100 years? All those things, first impressions. So we want to share with our families what they need to do. Now, here's another subject. You know your family members. Some of them in your family, they're going to drag their feet. They're going to act like they don't even know what's going on. So, you know, mother passed, you knew this day was coming. We've had this general conversation. Our auntie passed. We didn't realize she was leaving it to us, but she did. Uncle passed, you know, whatever. A lot of people just don't want to get past letting it go. They just want to hold on. So they're going to take a lot of time to make a decision, you know, something as simple as, do you want us to cash you out and give you your financial portion, or do you want to own it? You know, we give them all the options, and you know, I don't know what I want to do. I don't know, you know, and I get that, because when you're going through something as devastating as a death of any loved one, you're gonna have to have some time to think through it. That's why we're having this conversation, you all, because we want you to know that you should be having this conversation like right now, where everybody's in good health.
I think she is still with us. Let's see. So I think she froze again. She'll have to maybe go out and come back in. But Madam Governor is absolutely right. We do need to be having these conversations right now while people are still with us, or while they're, you know, of sound mind and able to make, you know, their feelings known about such things available to us. I have actually taken some of those steps to be able to do that. With my parents. I only have one parent left, but my dad was very adamant about the things that he wanted people to have, the things, you know, how we should carry forth after his death. And we did those things, and I can say it did take away a lot of the emotional sting that comes along with dealing with grief. We had a plan to follow, so we just did those things that he laid out versus trying to figure out for ourselves what he wanted. So Attorney Bostick, do you think that Madam Governor is onto something? Is that the way that we should be thinking about what to do with property that may be inherited to or left to us? And should we be doing that across like our family, not just leaving it? Oh, she's coming back in, so I'll save my question till the end to see if she can. Let me reshare.
I cannot explain this. This is very. I'm serious. This is very interesting. I cannot explain this.
I have made you the co-host again.
Okay, that's fine. And I'm gonna ask you to be ready to share the screen if it does it again, because
Okay,
it's the same thing.
I have it ready to go.
Okay, because I don't know, because I can do this without the screen, but you know, it just makes sense to have it since we've got it.
Okay, so let me go back here to, yeah, that might help better if we kind of do it that way. Let's see. All right, can everyone see my screen?
Yes, I can see it.
Yes.
Yes.
Okay, good. And so now I'm going to go back to, this is the page you were at, Madam Governor. Just let me know when to change the slide. Is she still with us, guys? Hmm. I think she went out again. So, Madam, Madam Miss Parliamentarian and Attorney Bostick, I guess I can ask my question until Madam Governor, and maybe we can discuss it until she comes back and she can pick up on her slides. So, do you think that's something that we should be talking about across families? Like, for example, I have had the conversation with my siblings and my parents. I only have one child, so of course we've had the conversation. But my grandmother told me some things earlier this year that I'm not sure if she shared with my family. I'm the only one that knows the things that she wishes. And so I did tell her to reach out to an attorney to make a will so that, she could have the wishes outlined. But does a will help when you have situations where people don't know what to do with inherited homes? And should we be talking to our extended family, cousins, uncles, about how to deal with inherited property?
I think that, yes, we definitely should have an estate plan. And that's one of the things I try to counsel with my clients about, is to always, if you know that you are dealing with the illness, if your parents are aging, grandparents, dementia and Alzheimer's is at an all-time high right now.
Right.
And so you should be expecting to do those things with your family. And I think that that's one of the number one things that you can do to protect your family and having heir property issues or any type of issues regarding what to do after they pass. So that is the number one safeguard, is to go ahead and have an estate plan. And then once you have an estate plan, is to make sure it's up to date. I recommend going over your estate plan yearly with your taxes. Every year you gotta do your taxes or whatnot. And that's a good milestone to go ahead and look at your estate plan, make sure it's up to date, make sure your beneficiaries are still alive, for one, and
Right.
that they're still in good standing to be, that you want them to receive whatever it is that you've left for them. If you've had any life-changing experiences, hold on one second, Madam Thompson. Is Miss Redditt in the building?
She is back.
You know what?
Okay.
Try keeping your camera off. Try keeping your camera off and letting her control the screen.
Turn my camera off. Okay.
Yeah. And let her control the screen. And just try
Can you
that.
control the screen, Kay?
Absolutely. I absolutely can.
Because my backup next time is going to be to dial in and talk on the telephone. Seriously.
However we can get the information, we're hungry for it.
Yes, ma'am.
Well, let me just say thank you to Attorney Bostick for answering that question for me. And guys that are listening, please make sure that, as we go through the information, that you let us know about any questions that you have. I'm going to let you pick right back up where you left off, Madam Governor, and sharing with us this screen and things that we should be concerned with when discussing what to do with inherited homes.
Sure. Okay. And so can you all hear me?
Yes.
Okay. And so what we want to talk about now is if you'll go to dealing with the inherited home, page 2.
Yes.
That's where we are. And so I just simply want to say that when you own real estate, just know that you're going to pay taxes and all of that. And of course, we want to keep your anxiety to a minimum and your stress to a minimum, because we know you're dealing with your loved one's treasured belongings. Okay, the next page, page 3, there's the financial cost involved. We talked about that, the plumbing, the heating, electric and cooling, all of the maintenance that's required. Even if you're going to sell it as is, you still need to know those things. And if you don't know those things, you don't have to disclose it, because tenancy don't require you to do that if you're inheriting it. But at the same time, you don't want to present something that's not true. So we'll be talking with you about that and why you want to partner with a home inspector if you need that to know what's wrong with the home. We know that everybody needs time when they're dealing with the passing of a loved one. We know that today's sellers believe that as soon as they list their home, they're going to get $1 million for it, regardless of where it is or what it is. And we have to give them facts so that they're really keyed into, for real, what's going on in a marketplace. As I said, whether you're talking about as is, where it is, or you're talking about the middle of the road where you're doing minimum things, or if you're going to go in and do a total rehab to make it give you the top dollar for the market. We want to make sure that we educate individuals about that, and certainly want to introduce them to the attorneys, the CPAs, and everybody who's a player, and we know who those are, because we sell real estate every day. Even though this is a different kind of product, those players still are necessary. Now we move into the benefits of selling this property. Again, it says no matter if you're single, or if you're a single individual, no siblings, you're the only heir, or if there are multiple heirs to a property, selling it as quickly as possible, obviously going to save you money and time and stress and the effort of going through escrow and settlement and all of that. So we want to make sure that you understand the legalities of that. We want to keep you focused on the steps so that we can minimize your stress, because it's very stressful. Most people are usually not going to do anything because they're confused and they don't know what's going to happen. So if we're informing them, that minimizes their stress and get them prepared for things that they had no idea was going to happen. And so every situation is going to be different. If someone inherits some property, obviously they're going to need you as a real estate professional. You know, you're going to have concepts about dealing with the family members. Everybody's going to have, typically you're going to have some family members, a lot of times, depending on the age of the person who passed away and what their relationship was, their family size. But most people are going to have some kind of family member. So it's going to be essential that you work to ensure that the disputes and disagreements are not going to lead you to litigation. Attorney Bostick can speak to that. In fact, I want her, when I finish this slide, I want her to give us an example of some things, because she's done a lot of that type work for us and others. And so she knows litigation is expensive. You don't ever want to go to court if you don't have to. And so you want to make sure that that's why you have this conversation like right now, when everybody's young and they right mind and all that, and they can talk about what if and a what if and a what if, because you don't want it to get to court, because legal issues are expensive. Usually they always tell us nobody wins in a legal case but the lawyers. I don't know how true that is, but anyway, that's what they tell us. And so we want to make sure that we have that conversation with our family members, including the attorneys at the table, to have a conversation via Zoom or telephone so that they can understand what the challenges would be, because litigation is never a peacemaker's choice. Trust me, people who, like myself, who we are into making peace, no, we're never trying to go to court, okay? And so I'm gonna ask the attorney if she'll jump in and tell us situations where you see where family members just do not want to work together. What are you seeing out there, Attorney Bostick?
Well, unfortunately, families tend to fall apart during these times, when it's, especially when the patriarch or matriarch of the family has passed away. And, you know, people have pent up frustrations, things they've been holding in for years, and it comes all out. And on top of the grief, it leaves the families devastated. emotionally, mentally, physically some, and on top of the grief. It's just a really difficult time. And I've seen a lot of families just fall apart during this process. And most of the time, there are some issues to work through. I've had families that bonded together and decided to do the right thing, even though they all may not have agreed. And I've seen some families just go to court and have an all-out, legal battle over pretty much their emotions. And most of the time, the disagreements are over property, air property, in and out of court. There are a lot of issues, especially when the individual did not leave a will. And everybody, and they're about, and you talked about, upwards of 28 heirs. I've seen like 2 pages, 3 pages of heirs in certain situations, almost hundreds, and acres and acres of land. And when you talk about land in Mississippi, in rural Tennessee, they have mineral rights, they have timber, and farms. And this is very rich in expensive property. And most of the time, the families do end up in court, and the property ends up being sold. Most of my cases with air property end up, we end up going to court over what we call a partition, is a forced court, a forced sale through the court. The court orders the sale of the property. And basically that's where a lot of these issues end up, or in a tax sale or in foreclosure. And, all of it is really preventable if prior to, you being ill or incompetent, is just to, even if it's in your own handwriting, just make an estate plan, make a will, and designate who you want to receive their property, whether it's a charity, whether it's one individual, 2 individuals, and just leave some instructions. You can, wills have to be done in a particular way if there's a formal will, but there is a way to handwrite a will, and it has to be totally in the person's handwriting and dated for it to be effective. But if that's all you have, I stress that that's what you do. Because most of these issues, especially over property, they don't end amicably.
You can say that again. I had a situation like that. It did not, it was between the sister and her 2 brothers, and it did not end well at all.
Yeah, and the thing is that it's all preventable. It's all preventable. Just everybody may not agree, but it is what it is. And, everybody has to comply with what the document says, as long as it's done properly.
Absolutely. And one of the more recent transactions we had was where a gentleman passed away. He was an older gentleman, older than his wife. His wife was older, but he was older than her. And of course, everything went fine, except when he passed, she was still legally his wife. And she said she wasn't signing anything. So we were able to locate the children. Everybody signed off. We're ready to close. She said she's not signing anything, and she don't care if his children don't get nothing. And that's what happened. The children got nothing. I got nothing. We put a lot of time in there, like 6 months, and it didn't close because when he passed away, he could have easily just gotten with an attorney like Attorney Bostick and did one little document and just did that will, or he could have, just quit claim deeded her off the property because it was just in his name, but because legally she was his wife at his death. So y'all know the rest of that story. And so we're going to talk about that and other items like that as we go through this information. Madam President, can you move us on over to holdovers? Go 2 slides over. Thank you.
Yes, ma'am.
That's it. There you go. Holdover. Now, everybody's familiar with this. You know, this holdover. Normally, real estate, we know this word because of tenants, right? But in selling real estate or state property, you have that same situation. In other words, it's always going to be someone in the family who wishes to remain in the property, and usually their conversation is simple. It goes like this: Mama said I can live here as long as I want.
Oh, yeah.
Yeah. So, I mean, we all have war stories about that conversation. And so just be mindful of that. If you have siblings or relatives that's living on a property, and you know, based on just a fact of life, call everybody's going to pass away one day, go ahead and have a conversation with your family and say, okay, at your demise, who do you want to have this property, and who do you want to retain occupancy of the property? Because little John is staying here now. If when you pass, do you wish for him to stay here in the property? Have a conversation, have professionals there to assist you with the dialogue and all. And just, just kind of softly start the conversation and let them know it's going to take a couple of conversations before they probably get it clear about what they really want to do. But by all means, have the conversation. You or your siblings may be living out of state. You don't want the property as in living in it, but you want your cash. That's your portion of the cash. You are an heir, legal heir, and you have every right to get that. But we've had that situation recently. We had helped a family, and fortunate for us, the property was in a trust, but the attorney's going to talk about that later. But even though the property was legally in a trust, you would think that means, oh, good, we didn't have to go to probate, we didn't have to do a lot of those things. But here's the deal: the holdover, the brother, he says, no, when they died, I was here, you weren't here, and they said they want me to stay here as long as I want to. Okay, now we know that wasn't the case, okay, but that's just what people say. And so we want you to be mindful of that and have a conversation with your family, making sure that it's clear in writing about what the future occupancy is of anybody's property. Because in terms of someone continuing to live there, I mean, are they going to be living there for free? If so, that's fine. Let's put it in writing. What is there going to be their responsibility for the maintenance of it? I mean, a lot of things have to be addressed. This is a very critical area of real estate that we do. A lot of times we don't just seek out to get that kind of customer. Those customers just know us and they call us. In the case of someone trying to continue to live there, I'm telling you, you're going to need to know attorney Bostick, because you're going to have probably go to court, to get some type of written instruction from the judge as to what to do with it. Because family members, honestly, I believe they believe this in their mind. If their mom or dad had passed away and they lived there at their death, in their mind, they for real think they're the only ones who have a right to that property. I'm going to stop and ask the attorney if she want to share anything about that at this point. Hold over.
Sorry, my mouth is a little sticky. Yes, that happens quite a bit. Where there are multiple heirs, normally siblings. And when you have heir property, no one person has more rights than the other individual or the other individuals. Even if one individual may own more property interests, percentage-wise, their rights still remain the same. And so a lot of times I have, believe it or not, I've had clients who, one particular client, one of the sisters, it was about 8 sisters, and one of the sisters and the mother purchased the property together. They lived together, and the mother passed away. The sister that still lived in the property owned half of the property plus a portion of her mother's 50% of the property. So she owned about 75% of the property. But the other sisters owned the other 75%. And they wanted her to buy them out or to leave the property. And they chose to go to court and do a partition because she wouldn't leave. Okay, and they ended up forcing a sale on the property. And later on, even after the court ordered sale, she wouldn't leave. So we had to go back and get a writ of possession for her to leave. And this case is actually still going on. It's been about 1.5 years. So it could get long and expensive. And if one individual is living in the property, has lived there, even if they're paying all the bills, and the other heirs no longer want the property or feel like that individual needs to buy them out, all they have to do is go to court, force a sale on the property, and it will force the person that's living in the property to either buy them out or leave. Because, you know, once the court orders the sale, they don't need permission anymore to put it on the market and sell it. That happens quite a bit. And, you know, some I understand, and some I think it's just unconscionable, but, you know, it's my job to be objective. But there are some family members that have, normally, like I said, normally it's a sibling, they just move on in and refuse to pay any taxes, upkeep, or anything, and they won't leave. So we end up having to go to court.
Guess what?
We end up having to go to court. So that is a big problem, as you stated, President Redditt.
So now, and you know, we see that all the time, you know, unfortunately, I mean, it is what it is. As long as people are being born, people gonna die. So we're gonna continue to see this. And it's just a blessing that we have people in our local market who can handle the challenges of this transaction. Another thing, Madam President, if you'll go to the next slide, we talk about the holdover slide too. It talks about if that sibling is sitting there holding over on that property, and like the attorney just shared, they can get their cash equal to the value of it. But you know, the question is, when are they gonna get it? They may not be able to get it in the morning, but they'll get it eventually, preferably, unless something else happening. If other people pass away, of course, that brings more people to the transaction. But just be aware that this is a very delicate situation. Also, you got to think about the leftover items of a estate could be very laborious. It could be time consuming and expensive for people. You know, people think, well, they passed and so they can just do what they want to with the property. Well, it's not necessarily that simple. Someone has to be put in the oversight of that particular task. So, you know, we find that we try to encourage them to think about things you want to sell, these things you feel have value. Let's talk about things you want to sell. Let's put them in this room. And this is usually where nobody's occupying the property. Then things you want to throw away, let's put them all in this room. So we try to get family members involved in the, you know, the task if they are locally. And then, you know, so you can have an estate sale because you can liquidate some of those items and that's cash back to the family. And then there's some things you just want to donate. You might want to give away, you might want to donate, you might want to throw away. You know, so we try to get them to think along that line so that it's not like a job for one person, because that can be very overwhelming. Remember that.
Governor, I'm sorry, I have a question about that. So if it's stuff that you're putting to the side to sell, how do you normally help them to do that? What process?
The next, yeah, we're
next
going
slide.
on to no, it's the next sentence.
Oh, okay.
We're gonna contact a local estate sale person. There are people in our market who does this. Their company was established just for the purpose of doing the estate sale. Or in our neighborhood, we might call it a yard sale, okay? But at any rate, that's how you liquidate those items. Sometimes communities get together and have a community estate sale, but that's what you do. You just let the families know their options, And then sometimes people just say, no, I don't want to deal with that. That sounds like work. I don't want nothing to do with it. Even if you say to them, all we got to do is hire this company who's going to facilitate everything. No, I don't want to pay somebody to do it. I mean, just whatever. So remember, we're dealing with humans, and everybody has their own life going on at the time of a loved one passing away. And so the last thing they're looking for is something else on their plate to do. So as much of it as we could get done so that they don't have to be hands-on to do it, a lot of times they are really open to that. But yeah, the goal is to get them to understand that when you do the estate sale or you put it on eBay, auction it off or whatever, again, it just depends upon the main thing is the number of people involved. Because if you're talking about 28 people that's involved in this, and we're going to sell this sofa because she just purchased it. I mean, you know, sometimes it's not really worth it because you're never going to get 28 people to agree on the process. That's what we find. And so you have to just think it through, try to find I call it the path of least resistance, where everyone can be on board with it. And for some people, they're like, I don't care what y'all do, just give me my part of the money. I hear that so much. Just give me my part. I don't care how y'all do it when y'all convert it to cash. So just understand anything you can imagine that you can come up with that might be what if, there's an answer for it in this industry, because there are professionals who focus on inherited property. Now, when we talk about splitting up items, the next slide, Madam President, you talk about splitting up items that's inside the house. You know, that gets real interesting because, you know, you're sitting there on the floor at the table, whatever, talking about things that's going to get distributed. And sometimes, you know, what I tell people is the best thing to do is to have a will. Even if at best you put it on a napkin or something like the attorney just said, have it in writing, because nobody's going to ever agree. You're going to see siblings arguing over a lamp. No, mother always wanted me to have that lamp. You know, I bought her that chair and she said when she passed, I could have it back, all of that. So that could eliminate that conversation. That's why we said where there's no will, that it's going to be difficult. You're going to get into a series of challenges. And unfortunately, again, nobody wins but the lawyers, because they're going to do what they call billable hours against the family to try to settle things that you all could have clearly discussed 4 months ago when you had your family reunion and y'all was sitting there at the kitchen talking to mama. That was a time you could have been talking about this. And who knew 4 months later she would pass? Nobody knew it, but there was an opportunity for you all to have at least have a conversation. I just believe that if I knew in advance what was the I'm gonna say the parent, if it's the mom or the dad, what was my parents' mindset? What did they want to happen to their things? Remember, these are things they acquired during their lifetime. So what was their mindset? And that's what I can tell you. If you can just be honest with your family, and they're going to say, I don't want to talk about that. Ain't nobody want to talk about no damn. I know we don't want to talk about damn. This is for the people who going to be living, that we can have this conversation. The person who going to die, going to be dead. They're not going to hear this. So we want to get this straight right now about what we want to do, because you're going to have sentimental things in the house. There's going to be some things that people will swear up and down that item has a $500 value, when in fact, if you want to pay an appraisal to give you a valuation, you're going to find out it was worth 15 cents. I'm talking about, I've seen this with my own eyes. So don't waste your family money with foolishness. Have a conversation. Talk about those things that you believe should go to this person or that person. Since the value of, sentimental values, the courts don't really get into that. But if you have an appraisal, an appraisal, but again, it costs money to hire an appraisal to appraise things. It's not free. I can't tell you how many families will call me and say, well, what about an appraisal? Can't they tell me what it's worth? Every day. If you got the money to pay them, they'll tell you. So the real challenge comes when more than one sibling wants that one item, okay? And that's where you got to have this conversation early. It's no sense of y'all pretending we're not going to pass away. All of us going to pass away one day. So let's just go ahead and have a conversation with our family and say, if you pass, who's going to get your books? Who's going to get that book? Who's going to just have fun with it and try to get a sense of, okay, At least we kind of know the direction this conversation would go should, when it, ain't no should, when it happens. Now let's go to the next slide, Madam President. Talk about these concepts to know when selling a inherited home. These are your options, by the way. Again, these are just the general ones we see. There are very few legal concepts, other issues you're going to be dealing with when you're selling your home. We want to make sure you fully understand your decisions so that you don't have to feel, can you imagine your loved one passing away in the morning and now you got to make all these decisions when you've had a lifetime to have this conversation? So think about this. You want to make sure there's a discussion about a will. The attorney's already talked about that. She's going to talk about it some more. A will is so important. It lays out the foundation, exactly what you want. It don't have to have every little thing in it, but at least it gets the conversation going. What about the inheritance tax? Everybody always want to inherit something, but are you willing to pay? The Tennessee has, and the federal government has taxes you're going to pay when someone leaves you things. What about property taxes? Did you know that the state of Tennessee, the city of Memphis, and the county of Shelby, they don't care that your loved one passed, they still want their property taxes every 30 days. Yes, they do. And so you want to make sure that you are aware of those items. Then you say, well, how they gonna know? Because it's gonna be reported to IRS. When you pass away, did you know that was a public record? Yeah, it's a public record that you passed away. And it's even more public now that we got social media, Facebook and Instagram. People can't hide it. As soon as they take their last breath, it's on Facebook. They died, and so it's no secret. So, you have a lot of, half of your Facebook friends, let me just tell you, work for IRS. So they gonna know. Okay. So they're gonna be sitting there ready to inform you about your obligation because you've inherited this property. What about the capital gain taxes? We just kind of talked about that briefly, but remember when you sell property that's not your primary residence, that you may have to pay a capital tax. There may be a consequence of you paying capital gain tax, a capital gain tax. And so you want to make sure you have a conversation early with your accountant, with your professionals. You want to talk to them early. Say, if someone were to leave me this, and it was their home, but I'm the next in line, I'm the next heir to receive this item in its real estate, or it's a boat, or it's this, go ahead and get those questions answered early so that when that happens, you're gonna be sad. Let me just be honest. Of course, we're going to be sad when our loved ones pass away, but at least I'm not going to be sad and devastated because I don't know what to do. And so that's what we're trying to do. We're trying to ease your mind about a conversation that you're going to have one day. One of the first things we want to look at, next slide, is whose name is on the property? Who owns the property? And so whomever had ownership of the property the day that the owners passed away, let's say it was just in your daddy's name, because your mom's already passed or whatever, it doesn't matter either way. And so whoever's name is on the property at their demise, that's who owns the property according to the state of Tennessee. So there are some things you need to do in working with the attorney. She's going to share that with us, some details. So this inherited property, while it sounds like it's simple and straightforward, it can be a little challenging, okay? And so the will help the legal team member help you through the process. But if there's no written instructions, that's what the will does. If there's no written instructions, or, if it's no written instructions, I mean, it's gonna cost you that much more money because you failed to plan. And when you fail to plan, you plan to fail. And so you're gonna cost your family more money. That's what we're talking about. We're saying if someone was nice enough and generous enough and thoughtful enough of you to leave you something, doesn't it make sense that you would be trying to find out the ins and outs of it before they're gone? Because they're gone. And so there's nothing to tell you what their intent was other than through this document called a will or trust. Now, in the case of inheritance real estate, things can be a bit more complicated because taking title to property, which shows ownership, can be modified, depending on the state, that you're the new owner. And that's where you're going to need a legal person like Attorney Bostick on your team. Generally, in this case, the executor of the will or the administrator is going to be nominated by the probate court to issue a new deed to the names of the people who are the owner of the property. Attorney, I'm going to stop here and ask you if you have any conversation about this.
This is everything that you spoke about is point on. And as your slide says, you know, the executor of the will, the administrator is nominated by the probate court and will issue a new deed that names you as the owner of property. I do have a couple of slides about that. And this is in the case where there is a will. In a case where there is not a will, it's a totally different scenario. But if you do have a will and you inherited property through a will, the only way to get that property is to probate the will. If the will is not probated, it remains heir property. And once the will is gone through probate, whoever the personal representative of the estate is, will normally, I would advise to do an administrator's deed to change the name of the property. That's not required, but I have seen cases where attorneys have opened and closed estates without issuing a new deed or filing a new deed, and it causes a lot of problems down the line. So I do think that it is important to make sure that the chain of title is accurate, that there are properly recorded documents, and that if you have questions, go ahead and ask those questions before the estate is closed, because once it's closed, it has to be reopened to correct anything. Did I answer your question?
Absolutely. And of course, questions are coming through and we'll be having those addressed in a minute. Now, so the next document, Madam President, it talks about what documentation do you need. Now, this is just a sample, just a quick look. Of course, you're going to need a copy of the death certificate. Of course, you're going to need, if there's a will, the probated will, if it's available. And then you're going to be, again, I always just call the attorney. I mean, Attorney Bostick knows, we just go call them. Okay, but you must at least consult that the original deed of the property to confirm that the property was not owned by somebody else at the time of the death. That's one of the challenges we see often, is that people will come forward and say, oh no, I know it said her name, but I was an owner too, and things like that. And so that's where you get into the litigation. Now, if the property is or was owned jointly, then the surviving owner will inherit the property in full. Therefore, you'll have to confirm whether or not you can inherit it by just the reading of the death certificate and determining the order of the inheritance, because that's one of the first things the lawyer is going to ask you. Do we know who the heirs are? And they've got to then, they'll ask you to go and help the family to get the affidavit of heirships and all those documents. That's how you'll learn this, these steps, because the attorney is going to need you to help facilitate it, because we're the front line, realtors, we're the people who the people come get first, generally speaking. And so they trust us, and we love that because we're an advocate for them. And so they're going to generally just go and do what we ask them to do, that the lawyer is asking us to tell them to do. Okay. So if the person that inherited the property has died first, and then they left behind what they call a co-owner, that means two or more people own it, then the property would simply just revert back to that individual, leaving you to establish your claim as a legal heir to the property. If the will lists you as a person who's inherited it, then you will be required to do what they call an executor's deed. Now, I know that the attorney got a set of slides that she's going to cover with us before we leave this event today. And I'm excited because she's going to give us some legalities of this stuff. And so just know that when someone passes away and they call you and they say, hey, we want you to sell our house. And the first question you're going to ask is, what's motivating you to sell today? That's kind of how we get to that question. And then they're going to say, well, mother just died. And so that's when you start getting into these series of questions that the attorneys have provided us with basic questions to ask when someone dies. Okay. And so the next slide, I'm gonna just move right quickly through these slides because I know the attorney got a set of slides. You definitely want to talk about some legal stuff. According to the legal definition, a life estate, you don't own it, you just own it during your life. So during your life, long as you live, that's what they're talking about, life estate.
Right.
And of course, it can be a life estate on your life, or it can be a life estate on somebody else. That's called per attribute. Anyway, if you own it, that's why the Tennessee don't consider it quote ownership. You have a right to the use of it, to occupy it or rent it out or take a loan against it if the bank want to do that to you, if that's what they see your position on the title is, and all that stuff. And so just know a life estate is certainly a option given to a person like a family member. In other words, I want my daughter to have this property as long as she shall live, and then in her lifetime. So what is the question is, how long is that? As long as she shall live. We don't know how long it's gonna be. Or I want her to own this property as long as my aunt live. Why? Because she's the caregiver of my aunt. Okay, that's per attribute. Okay, so again, just the lawyer can help you with all of those legal words she's gonna cover. Title may also return to a person who gave the deed when this person, so my daughter had the property during her life. And the lawyer is not gonna let me just do a life estate just like that. They're gonna say, okay, but since she's not gonna live forever, who gets it after that? So they're gonna find out whether it's gonna do one or two things, either gonna revert back to the original person who granted it, or it's gonna go to the person who they deemed to get it after the daughter's death. And that person is called the, I'm losing words here. What's that word called? The remainder. So the person who gets it after the life estate is the remainder. If it revert back to the original grantor, it's called a reversionary right. Again, the lawyers can help you with that, but here's what you got to know. Sometimes we want to grant people the right to live. You in the street, y'all, this is how it sounds. My uncle lived in my grandmama's house, and he been living there ever since she passed, because she said when she died, he can live there as long as he shall live. We're talking about that. That's a life estate. And there's lots of those transactions in our community, lots of them. We just didn't know the legal words, but that's what they're talking about, a life estate, doing the life of the uncle. Long as the uncle shall live, is his house. Well, somewhere in that same document, it's gonna tell us what to do when Uncle Joe pays, okay? So the lawyers are not gonna leave it loose-ended, is what I'm telling you. Attorney, you have anything else on that before we go to the next word?
I did have a couple things about life estates, and
Right.
that's one of the things that I do recommend, depending on what you want your outcome to be when it comes to your property. The one caveat I would like to say is that when you do add someone else onto your deed, if you are of the age and you're getting some type of tax freeze or tax incentive, adding a person on your deed will affect your tax incentive or your tax freeze if you are eligible for that. Because what happens is they include everybody's income in that calculation. So just keep that in mind. If you are over age 65 and you're eligible for a tax incentive or a tax freeze for your property taxes, adding someone on your deed or adding a life estate will affect that. So you just want to make sure that that doesn't happen. Also, if you give yourself a life estate, you no longer own the property. And if that individual who's the remainderman, as Madam Governor stated, if you're still alive and that person dies before you, whatever their estate plan is or whoever their heirs is, that's where the property is going. And then they have ownership of the property and you just have a life estate.
So can I interject there? So, because this stuff always interests me. So the person who is losing. So the person who assigns the life estate, that person has to revert the remainder back, right, to the previous. You have to write into your plan how to get your property back if the person you're giving the life estate to dies before you. That's what I'm saying.
Correct. There has to be some type of plan or document
For you
that
to get
says
it back.
for you to get your property back. And some people are not aware of that. And so if you go ahead and transfer the property to someone else, like your daughter or your son, and you just give yourself a life estate, and the purpose may be so they don't have to go through probate to get the property. However, they pass before you. They don't have a will and they're married, no children. Well, that person's husband now or wife now owns your property and can sell it, or after you die, can do whatever they want to do with it. So you no longer have control.
So this would be something that would be good for a parent to, like, let's just say you're a parent and you want to help your child buy their first home. You're giving them cash, to buy their first home, and they go and get married. If you wanted to get your house back, then you would have to do something to keep them. How does it work if that happens? Like,
so
you're keeping the house and then, but you want it back, like if something happens to them, but they have a spouse.
Mm-hmm. They would need to have a will, willing the house or devising the house back to you if you're the parent and you want that house back. Or you can create the deed with joint rights of survivalship with just you and that child. And that way, whichever person passes first, the other person gets the property 100% interest. It doesn't go through heirship.
Gotcha. Okay.
I
do have another question, though. I think it's fitting here. It's from Jada Davis, and it says, if a probated will has one name and the deed has another, which will be considered first?
So if the deed is no longer in the name of the decedent, and that's the person who passed away, then whatever is recorded in the deeds office takes precedent. In order for any property in the last will and testament to be conveyed to the person in the will, it has to still be in the name of the decedent, the person who died. If not, it would be presumed that the individual intended to give their property away prior to their death. And it would be excluded from the estate.
That makes sense.
That makes a lot of sense.
Yes, ma'am.
I do recommend life estates, but narrowly depending on what the plan is, but it is a very useful tool.
Right. Okay, let's move to the next slide, Madam President, and talk about this living trust. I've had the privilege of helping some families with this instrument, and it was great, as I said, except that sometimes, people think because they physically occupy the property, they didn't think that had anything to do with the trust. And so it was great for us because we didn't have to go the extra period of probate and all of that. So a living trust has come to replace the role played in life estates, which is not commonly used today. However, there are some advantages to this form of inheritance. For example, this method is useful to the heirs as it means the increase of property value following the death of the decedent. So a life estate can also help avoid probate, which is a legally required process to transfer property from a deceased person to their descendants, and by which can be sidestepped by using a life estate instead. But since it's not technically an inheritance, a life estate also could be called an instant transfer. Now, to my understanding, and the attorney is going to tell us this, A living trust is what you do when you don't want to have to go through the cost and cumbersomeness of going to probate court. It eliminates that probate court step. Attorney, you can speak now. Tell us what we need to know about a living trust.
Okay, so the living trust, I'm recommending trust more and more over wills because, of course, it keeps you out of probate most times, and also it acts as a form of added protection. And when you put your real estate in the trust, you have a little bit more control over what happens with the real estate before and after death. Living trust, when you have a living trust, that means you can have, most people do revocable living trust, which means they are the trustees and the trustee and the grantor of the trust prior to them dying. And then once they die, the successor trustee takes over. And trust can be created with as much specificity, I can have trouble pronouncing that word, but they can be as specific as you would like. And you can designate when, how, and what manner your successor trustee is to take care of the property, if it be sold, and the proceeds be left in the trust for a particular person at a particular age to be used to pay for education or anything. I love trusts because they're so customizable. And most people that have wealth, life insurance policies, a lot of real estate, I strongly advise them to do trust instead of wills because they continue to have control over the items that they put in the trust, and also they can have more control on how those items are distributed or assets are distributed after they pass. And trusts also have wills attached to it, which we call pour-over wills. And that's to catch anything that is not specifically named in the trust. That pour-over will would, in essence, what we call catch everything else and put it in the will. Put it in the trust. And so a revocable trust allows you to change it while you're alive at any point that you choose to, and also choose the beneficiary and the successor trustees and customize how your assets are distributed after your death as specifically as you want to. Wills have limitations when it comes to some of those things.
So what other things can you include in the trust that would be of value? Or do people mainly use living trust to convey what they wish to happen with the real estate? Or like if they have valuables inside the real estate, can those things be added or no?
You can add anything you want in a trust. Real estate, life insurance policies, valuable jewelry, automobiles. The thing with the trust is that you have to, the asset has to be in the name of the trust. So if you want the real estate to be included in the trust, then the real estate has to be titled to the trustee of the trust.
Gotcha.
Okay. As well as your automobiles, your life insurance policies. All of those.
You can't just throw Uncle Joe's fishing equipment in there or his old car from, you can't just say, I'm just, because people will say that, well, he had a trust and everything, all this stuff was in it. So you can't just do that. It has to be something that has been named in the trust, or it has to share, like you said, a name. So,
right. If it's a titled asset, it has to be titled to the trustee of XYZ Trust.
Gotcha.
If there are personal items, of course, those are not titled, but you would specifically list in the trust that I do. I have an index page with blank pages for gifts and all kinds of things where you can write down what, if there is an item that doesn't have a title. I want my daughter to have all my my china, or I want my son to have all my furniture. Those things are not titled. So you just list those things, but things that do have a title or ownership, you do have to include the trust as the owner of the property. Now, where the pour over wills come into place is the pour over wills allow everything that is not in the trust to go through your estate, but the beneficiary of your will is your trust. So then your executor over your will is able to title those things to your trust and dump it in there. And that's what we call the pour over will. So the purpose of the will is to catch all the things that's not specifically put into the trust that you may acquire afterwards or not thought about putting it in there. And it allows your personal representative, who is usually the trustee as well, to title those things to the trust so it will be put into the trust.
That makes sense.
And that's a safety precaution to make sure that everything, your wishes are carried out.
Great. So we'll go to the next slide, the distribution, which we just covered most of that, talking about distribution of items among the family members. Talks about while drafting a will, its maker usually make provisions for major parts of their estate: cash, stocks, expensive jewelry, and heirlooms. However, it's common that people do not make provisions for most of those other mundane things in their will, like furniture. The attorney just talked about those items. But one thing I would like to mention here is what people, when they're talking about they want to do a trust, they have to understand that once you put items into a trust, you, the person, no longer own that thing. So let's say, for instance, you put your duplex in the trust. You can't turn around as an individual and write off expenses against the duplex because you don't own it. Attorney, can you speak to that?
Yeah, so once you title your property to the trust, the trust or the trustee now owns the property. Most revocable trusts are owned by the person that created the trust, which would be we call the settlor, the grantor, also is the trustee as long as that individual is alive. But the property is no longer your personal property. It belongs to the trust at that point.
Thank you.
So you do have to title your real estate. If you want to put your house in the trust, you have to put title your house to your trust. If you want your life insurance to go into the trust, you got to call your insurance agent and say, hey, I want to change the ownership of my life insurance policy to my trust. Those things have to be done, and that's called funding your trust. And without that, your trust does not own anything.
Absolutely. Thank you so much for that. And Madam President, we can go to the next slide. It talks about the sorting out of things in the house. We kind of touched on that already. Remember, is the first step is going to take time, energy, and fortitude for you to go through these things with your family members. So be very aware of that. Closely watch that, because as soon as someone passes away, first of all, we go through those psychological, emotional feelings of, what we gonna do and all of this. And, it depends on if you're a single person who's a heir or is there other siblings. So you want to think about how you're going to discard those things. And remember, before just moving on or selling the auction items, it's crucial to establish boundaries or limitations to those in the family who get the first right to those sentimental items. Again, I always just advocate, have a conversation with the family, try to put it down in writing, and, you know, just be prepared because that day will come. Next slide, dispute over distribution of personal property. There has to be a mutual agreement between the siblings and the family members who get to keep certain items, particularly the sentimental items. They're going to be the ones that's going to be more in dispute. In the event of a serious dispute, we talked about that earlier, where sometimes you have to bring in a mediator or arbitrator to settle things. But again, it's not free. And so you want to make sure as a family, if you can forego those things and just have a conversation early with your family members before that day comes, so that there's no excessive money being spent on things you all could have settled in advance. And so just know that's an equitable system by which a family may not want to liquidate everything, but they want to maintain some things. Next slide. Selling valuable items or property and distributing the net profit equitably. We talked about that. And all of this is the wisest thing you can do is get a professional from your real estate investor, agents, attorneys, anybody that are major players in your market that knows what they're doing in this particular space. This is not you're selling a regular type house. They can give you a personal perspective from experience on how to sell the house at the highest possible value. Nowadays, it's more convenient and customary to sell any unwanted items online for extra cash. We talked about that. Such professionals can provide you an estimate of valuation. If you don't know what something is, do not hesitate to go out and Google it or call someone. And again, they can charge you. Sometimes these professional auctioneers or individuals can charge you either by the hour or per the project, depending on where the property is located and all of that. So just know that there's some solutions. Next slide, downsize to inheritance. So how do you sell a house to an estate and how do you determine the valuation? Let's go to the next slide called 4 ways to sell your home. This is the most important slide I believe there is, because in my experience, these are the 4 things I'm saying. 1, you could do an auction. 2, you can sell it outright to an investor. 3, you can sell it for sale by owner. They passed away, they left it to you. If you know what you're doing, sell it. But I recommend number 4, hire a real estate professional agent who you know for a fact they know what they're doing. Next slide. Let's talk about the pros and cons of each of these 4 things. For an auction, the pros of an auction is simply if a buyer takes over, the bidding war can be fueled by their emotion, competition, and ego is going to get in the way. Nobody don't want to lose. So they're going to keep bidding higher and higher because sometimes it's not even about the money. It's just about, I got it. Okay. You know, y'all know that. People get caught up on an auction and end up paying more than they should have just because they have a mindset to say, I won the bid. The house is sold as is. So know this, in an auction, what is, where is, and what is. And so no repairs are going to be expected to be done by the seller. That's why it's important if you're helping someone that you know these things. The seller's not making any repairs. What you see is what you get. You can also leave things in the house. You may not have to call a company to do a trash out, maintenance, contractors, things like that. What they see is what they get. Other than repairs, you also wouldn't have to worry about an inspection from the city. If there's a code enforcement violation, okay, if what we call runs with the title, it just goes right over to the buyer who's buying it. There are hardly any contingencies, in fact. And what I like about auctions, if you just have to do this, the deposit is very high. So it eliminates the looky-loos, people who just looking. People who are serious know that they're going to have to put up a sizable deposit, usually about 10% of the contract price, or 2,500 or some number like that you're not willing to walk away from. And so, and then the property has to close within 30 days or less, because they'll set the rules up front before you go to bid for it. And of course, the buyer's going to forfeit the deposit if they don't proceed with the terms of the auction agreement. Those are the pros. Now let's look at the cons, the downside. The biggest downside to an auction is that it's unpredictable. The outcome is uncertain. You can be left with much less than what you were hoping for. This can be mitigated by setting a reserve price, but that still could be a problem. You got to hire a skilled professional auctioneer. and the skills come with a price tag, there is no guarantee that you will successfully sell your property at an auction. In fact, statistics shows only 75% of properties that are advertised in an auction actually sell at a success sale price that the seller wanted. And then you got to know that there are some auctions that are like, it's like definite, like you can't back out if you don't get what you want, you know. And then regardless of whether the property sell or not, you still got to cover the cost of the auction. And so number two, if that don't sound good enough for you, you can certainly sell it to an investor. Now, here are the pros of an investor sale. A big perk of selling your home to an investor is that they will buy it as is. That means when they buy it as is, I've seen them buy as is properties, as is with the stuff in it. They don't care what's wrong. In fact, they never saw it. We don't have to see it. We want to close in 6 days. That's how investors talk. The investor's more likely to buy the house. They want houses that need repairs because that way they can get it for cheap. And usually the repairs that they're going to make are not even what you think. So that's why we got to be knowledgeable of this so we can help our client make the right decision. A buyer who wants to move into a house, like I want to move in and start living, this wouldn't be a good option for you. There are times that an investor won't even have to see the house. I just said that because most times they just gonna flip it, wholesale it, whatever. Another benefit to selling to an investor is it's more dependable and quicker. They want to close quick. And you have to really watch them though, because they'll make you these wonderful offers. They want to close quick. Then they come back after they do an inspection and say, oh, well, I didn't know it had this or that. It was like this. And so we're going to have to go back and counter our offer. Okay, that's fine, but we can't sell it to you at that price. So, you know, in other words, you might lose months and months and months because what they're trying to do is go find an end buyer. So be careful with the investors, okay? Just know you're dealing with professionals. We know the game. And so make sure you all talk to us, or talk to you all, the professionals on this call. You know who you are. Make sure we get the word out to our family members, because a lot of times when you lose time like that, somebody still got to pay the taxes. They're still paying the insurance. They're still maintaining it. You know, the city of Memphis, I don't know if y'all know this, but they're going to charge you $200 if they have to come cut your grass. And I know this for a fact, even if they don't cut your grass, they're going to have a picture saying your grass needed to be cut, and they're going to have a $200 lien on your property. So be careful with all that stuff. Make sure your families are aware of things that can happen. Selling your house as is sound real good sometimes, but might not be the right thing for the family. Again, that's why you want to have a conversation with the family. What is the cons? What's the downsides? Next slide. So the con is what you're going to receive for your house. An investor could, of course, they're going to profit from it. Now, they're supposed to say, I'm buying your house because I'm going to fix it up and I'm going to make a profit. Well, you know, investors don't tell the truth. They're not going to tell you that, but that's for real what's going to happen. And so for them to even be interested in your property, they got to pay such a low price. And many times that's just not good for the family. That's why I like to have conversations with families long before they need me in this space. And so, but if I don't have that conversation in advance like that, when it's time for me to be introduced to them, I tell them everything I know and give them all these 4 options. Now, it is not suggested for you to sell your property to an investor unless you're in a dire situation. And I can't imagine nobody being in that kind of situation right now, because there's a buyer out there for everybody. Okay, next slide. Selling a house for sale by owner. You know, most humans, they like to, everybody think, well, let me say this. Everyone believes that they can sell their own home without a real estate professional. You know, they don't think they can be a lawyer. They don't think they can be a doctor, but they think they can do real estate. But it's okay. That's what they think. And so just know this, for sale by owners. In their mind, first thing, they don't want to pay a commission. That's their number one motivation. I don't want to pay anybody to sell my house, which they never understood. The truth was it costs them not to have a professional at the table. They get full control of the process, both pros and cons. They get to pick the price. They get to show the house. They get to run over there 8 times a day and show it. They have to understand the legalities of what's expected from them to sell a home in this market during this time, in terms of disclosures, all those things. It's their responsibility, solely theirs. They wanted to sell it themselves. That's what they're going to get. You're going to get what you pay for. They have a lot of social media channels. They believe they can just put it out there on Craigslist or put it out there on for salebyowner.com, homeforowner.com, or Zillow. any of those sites, I can just put it out there and sell it myself. And I love the ones they tell me today, oh, everybody's calling me and want to buy my house. I said, I know they do. I said, do you have it in right? Oh, no. I said, okay, tell them to put it in right. When they call back and say, well, I told them to put it in right. And they said, well, they don't want to put it in right yet. I said, yeah, that's how they do it. So be careful with those investors and stuff like that. Now, the cons, what's the con of selling your house yourself? Of course, the home could sell for a lot more. You know, I love for sale by owners. I really do love that group because, you know, they make my day. I don't have to do so much work trying to identify where they are. They put a sign in their yard. They even put their phone number on the sign. Look, okay, and so you can call them and have a conversation, show them how you can help them sell their home and get more money for it. Some people buy in that, some people don't. But the thing you got to know is when you sell the house yourself, you're going to have less visibility because you don't have access to all of the systems we in the real estate professional have, the big one, the MLS, okay? My MLS system can allow me to put a house in the system and somebody in Hawaii can know it's for sale. Someone in Paris can know it's for sale because it's feeding through a third party provider. And so know that as a real estate professional, we have so many more tools available to help them sell their property. And so we try to discourage them. I discourage them with this next one. Do you know the legal forms and disclosures you have to fill out when you're selling the home yourself to the buyer? No. What are they? I said, you're going to need me. Call me if you need me, but you're going to need me because you don't want to take that risk. You don't have a legal liability of selling a home to someone and you didn't know that as a seller in the state of Tennessee, that there's a document that you must disclose the condition of your property. Oh, well, how do I get that? Call me, hire me, I can help. Okay. Now, again, for sale by owners, you know, sometimes they go to YouTube channels, they go to all these different internet portals and they talk about they got trained on how to sell the house themselves and all that. I mean, if it works, it works. And if it don't, always remind them to keep the door open and call me. Now, it might be harder for them to weed out these people who just coming through their house. This is what I tell them too. I said, you mean to tell me you're willing to open your house up to strangers you don't know? How are you vetting them? And they'll say, oh, they said they wanted to see it. I said, are you sure they want to see your house or do they want to see you? What are we talking about? And so the risk in this day and time, it's not even worth it to try to say that little commission that you all gonna pay us. Trust me, it ain't worth it. Life is more important than a commission check. People, a lot of times just think about, I don't want to pay a commission. That's all they think about for sale by owners. And they don't think about the security implications. They don't think about the legal implications. They just don't think about it. They don't think about all those people coming in and out of their house in this kind of time with COVID and all these diseases and stuff going on. And then guess what? They may not even be in the market for real looking for a house. They may be in the market because they're a serial killer. I don't know who these folks are. I'm just telling you, in my mind, I'm going to try to talk you out of being a for sale by owner because that's what they hire me to do. They train me to convince you not to be subjecting yourself to those challenges. These types of people who are inquiring, they're going to waste your time and they're going to distract you from having a real live buyer who could have bought your house 2 weeks ago. Next slide. I advocate for this one. Of course I do. I'm a real estate professional. This is my 37th year. I know what I'm talking about. And a lot of my colleagues on this call as well. We want to make sure our community know who we are. That is what Women Council of Nedra Memphis chapter is doing. We're getting the word out. Don't put your life in jeopardy over trying to save a commission that you might not even live to witness. We want you to know that the most common way to sell your home, and statistics shows this, it backs it up, that the majority of the people who sell a house, they use a real estate professional. This might be the least risky, most reliable for you to sell your house, even if it's an inherited piece of property. In today's real estate market, the selling and purchase of a residential property can involve over 100 people or more. I mean, it's just a lot of folks involved between the buyer and the seller. We have all kinds of levels of experience and expertise. We know the players. We know everybody in our market. We know the closing attorneys. We know the title companies. We know the home inspectors. We know the appraisals. We know everything. We know the market. We know this stuff. This is what we've been doing for years. And we can help you get to the sale and get it closed so you can go back about your business. And so we try to explain that to our community. We want to continue to have this dialogue to get the word out. As a seller, it can seem overwhelming, particularly when you tied into someone that you love just passed. Who has time to be trying to sit down and figure out what the best value is to go to the market? You go to the market too low, everybody in Memphis wants it. You go to the market too high, nobody wants it. So you sit there, you're losing equity. You don't want to do that. We want to make sure that you're working with an experienced real estate professional who is knowledgeable in all phases of real estate and can make this whole process so much easier for you. You do not need to have a background in real estate. They often say, well, maybe I should go to your school. I said, you can do that after we close, but you don't need to have a real estate license to do what I do because I already know what I'm doing. By the time you figure out what I'm doing, you will have been lost your money in your house too. You don't need to have real estate expertise if you engage a professional who has it. Next slide, Madam President. No matter how long you've lived in your house, this was interesting to me. Well, I've lived in my house forever and I know everybody, I know. But guess what? A real estate professional in your local market, we have way more knowledge. We have considerable more knowledge about the sales price, the market conditions, what's going on, who was in, who was out, why they sold, when they sold. We know all of that. We have access instantly at our fingertips of all that kind of marketing trend information. And since the real estate professional is paid on a commission, what do you think I'm doing every day? Waking up saying, thank you, God, you woke me up this morning. And now I'm going to go out here and help somebody sell and buy a house. Because that's what I do. I get paid on commission only. So don't I sound like I'm motivated? Of course I do. It is in our best interest to go out there and get you the maximum dollar amount for your property, given the condition. Given the condition. We want you to know that we're not going to tell you anything that isn't true. We want to give you the true facts about the condition as it stands today on this day, June 11th. Now it could be different tomorrow on the 12th, but on the 11th, this is what the market shows. Real estate agents, we have a network of professionals like this invite, this event that you're on today, Women Council and Nedra and all these other organizations we're party to. Real estate professional network with so many professionals all across our city, county, state, and the United States. We can advise on service representatives, contractors, termites, locksmiths, stagers, all of these professionals. Because why? Because we've worked with them ourselves. I wouldn't dare recommend you to work with somebody that I have not personally worked with. So next slide talks about why would you hire an agent? We're wrapping it up. A professional agent wears many hats. We must be proficient in so many areas. It surprises me every day. We have to know marketing, negotiating, consulting. We have, when they talk about legalities, in other words, I got to know the lawyers who know what they know. Property taxes, we got to know those people in that department. And most of all, we have to gain the trust of our clients. An agent who will meet your specific needs is certainly worth the commission they gonna earn. Next slide, talk about what are the benefits, real simple. When you hire a real estate agent to sell your property, the agent is gonna negotiate from a different vantage than they would just a regular normal house where somebody can move right in. Unlike most buyers and sellers, you can remove yourself from the emotional aspect, but we're not in that deal. We're not emotionally tied to that transaction. So we're open-minded, we're level-headed, we're looking at the facts, only the facts. We're not getting caught up in there like if we were a benefactor of that sale. The real estate agent can be a buffer between the buyer and the seller. That is so important. You shouldn't want the buyer to know who you are if you're the seller. You know, that's how you're going to mess up your negotiation position. I'm having to tell sellers that every day. Oh, I hadn't thought about that. I know you hadn't. That's why you hired me. The real estate agent can help you filter through the people who are inquiring. So many times when we have listings, our clients are calling us saying, hey, this investor said he want to buy my house. I said, perfect. Give him my number and give me his number. And I call him, hey, she said you want to buy her house. Oh, you're a real estate broker? No, buy. I said, okay, buy. See, they don't want to buy a house having to deal with a professional like myself. They want to deal directly with those sellers so they can take advantage of somebody. Good agents, we're not just simply go-between messengers delivering all for paperwork back and forth. We are trained to advise our clients on their options and the consequences of their choices. And we do that so well. Having a real estate agent when the house is being shown is a distinct advantage. Can you imagine how many times we have to show a property or go over and make a property available or answer questions, field calls and stuff like that? If the seller had to do that, they would quit after the first week. Trust me on that one, I've seen that. The agent is also the one who's going to be available physically to show the property. They're going to be there to answer those questions, and those sellers are going to love you. It never fails when we get to the close and they say, wow, I feel like Ms. Redditt, I owe you some more money. I said, we'll talk about it on the sidebar. Okay. Last thing, how do you choose a real estate agent? We're coming down to the end, to the close. I got to get the attorney on these last few minutes. How do we choose an agent? You choose somebody who's current, connected, knowledgeable, organized, personable, and passionate. You know those folks in your market. If you don't know them, now you know us. We're on this call. You want someone who has tenacious, who's honest, self-motivated, creative, and tech savvy. You certainly want those kinds of individuals working on your behalf if you're going to be selling your property using a professional. There are going to be questions about the process. The seller gonna have questions every day, if not every other day. And particularly if we're talking about air property, they're gonna have questions every day. And you gotta be available. You can't be talking about, I'm on my real job. I can't talk to her. I can't do nothing until tomorrow. You look, people hire you, you better be available. We are available. We're full-time professionals. For example, if we got a question about the tax authorities, we know who to call over at the tax office. Tax assessor, we know who he is. We know all of the players in this industry who's going to help us get this transaction closed. A good real estate agent, know they got to deal with these issues. Questions going to often arise, and they can be overlooked if you're not dealing with a professional. And even if I'm sitting at the closing table, how about that? They still come up with questions. I'm so excited to be able to deliver to you all this information. Last slide, Madam President. Other ancillary professionals you'll find on your team, keep going, that one. Now, the attorney, you're gonna hear from her in a minute. She got some slides to share. Insurance agents, you know you gotta have insurance agent. Contractor, clean out, trash out, maintenance contractors, your lenders, stagers, property inspectors, termite contractors. The list goes on and on that I could tell you about the individuals that you're gonna have on your team when you're doing this type of business. In conclusion, last slide, dealing with the passing of a loved one, especially when it's your mother or father, it can be a long-term process. I've seen people let the home just sit there 3, 4, 5, 6, 7, 8, 9 years because they just still trying to figure out what they're gonna do. That makes it even more complicated because things change over time, condition, all of that. So whether the loved one passing was expected or not, the turmoil involved in grieving while you're trying to handle a major transaction like this is incredibly stressful. Let me say this. I know this personally. Our mother passed on September 25th, 2003. Now, what was interesting, I had listed her home. Fitzgerald and I had listed her home 30 days prior to her passing. Now, of course, my siblings said that's what killed her, but y'all know that wasn't true. This process was not overwhelming to my family. Why? Because Fitzgerald and I knew the necessary steps that we would have to take in order to get this property closed, get her personal property out, and get everything in position. See, remember, death is gonna happen. You just gotta be prepared. If you're the one who's the heir, and I tell people all the time, if you believe you're gonna pass away and you don't have anybody that you like, that you wanna leave your stuff to, look, my name got 2 D's and 2 D's and 2 T's in the last name if you need to put my name down there as your heir. Remember, and the lawyer gonna speak to this, I don't have to be related to you for you to leave me something. Now, we're so excited that you all decided to join this event that we're gonna give you this free ebook. This is just a token of our appreciation. And after you read through it, if you believe you need our help or family members need our help for us to sit down and talk about a specific plan that works for you and your family, do not hesitate to contact us at the Redditt team Realtors, Nedra, Fitzgerald, or Camille. Madam President, I'm turning the call over now to Attorney April Bostick, and she will conclude this call for us from the legal perspective. I know I left out a lot of things.
Thank you so much, Madam Governor. We will definitely have to do this again because as we know in our industry, things are always changing, updating, and you have given us a perfect foundation to begin to discuss this stuff with our families so that we can be able to, you know, make some sound decisions proactively instead of reactively. So with that being said, I'd like to go ahead and give the floor over to our next presenter, Ms. April Bostick, who has a few slides for us and some things that she wants to share in order to conclude this wonderful event. Attorney Bostick, you may go ahead now.
Thank you for having me. Madam Governor, presentation was excellent. She hit on a lot of valid points, and I'm just going to kind of touch base on some of the things that she went over in her presentation. I'm going to try, am I able to share my?
I could definitely have you
Okay.
share you in just a moment. And I stopped my sharing. You have the floor now.
Thank you. All right. Are you all able to see my screen?
Yes.
Okay. Well, this is first slide is just a little about me, what I do. My firm is Bostick Law. I'm a Memphis native. I graduated from University of Memphis, law school in Memphis. I've been practicing for about 14 years in the areas of real estate, probate, estate planning, asset protection, business and family law. And this is my disclaimer. The information presented in these slides are for informational purposes only. Everyone's circumstances are different. Please reach out to me or a reputable attorney competent in real estate and probate for advice concerning your specific situation. All right. I'm going to just touch on the ways of inheriting property. You can inherit property two ways. One, through a last will and testament, which the legal term for that is testate. And in the will, there could be heirs or beneficiaries. The second way is through the state statute, which would be an intestate succession. And the Tennessee Code has codified has determined who your heirs are if you don't otherwise have an estate planning document giving your property to anyone in particular. And that's that law is TCA 31-2-104. And when an individual dies without a will, that is called intestate. So if you hear someone say they died intestate, that means they died without a will. So when a person dies in Tennessee without a will, any real property that they own vests immediately to the heirs of the decedent. So as soon as they pass away, the property goes directly to the heirs. All right. First, we're going to talk about inheritance through a last will and testament. There are two ways to probate a will. And if being that when a person dies, their property goes directly to their heirs, until you probate a will, the property will be considered heir property. And there are two ways that you can probate a will. One is through a full administration, that's just admitting the will for probate. The second is through a monument of title, where the will only contains real property. Now, I've had situations where I've had clients that have gone to closing agents, different real estate companies with what we call decedent estates. And decedent estates can be a little tricky because if you don't know probate as well as real estate, you can't see the big picture. And especially when there's a will involved. So if you have clients or if you have a family member that has a will and there is real property involved and you have a legal issue, make sure you consult a lawyer that has experience in real estate and probate, because sometimes those two overlap. And if you don't understand a probate issue, you're not going to understand how to resolve the real estate issue when it's involving heir property. So there are two ways to probate a will, and that's a full administration. That means going through the whole gamut of the probate process, or number two, emolument, what's called emolument of title. That is an abbreviated version of probating an estate with a will for only the purposes of devising the real estate. So normally when a will contains only real estate, the court will allow you to come in court. It's a one and done kind of situation. You go in, you address the judge, they read the will, and then they issue an order titling the property over. And that court order is recorded in the registrar's office like a deed would be recorded, except it's a court order. Some judges will allow you to probate a will through emolument of title if there are other personal property items in the will, but you have to have a receiving waiver saying that everybody who was supposed to get a personal property item or whatever else is in the will, they've gotten their property, they sign off on it, and it's presented to the court on the affidavit. So when you do, if you're able to do the abbreviated process, it's less expensive and it's a lot faster. But you have to be sure that the real estate is the only thing that's of issue in the will. And the only way to transfer a title of property that's in a will is to probate it. Otherwise, it's heir property. Okay, and the will must be properly executed. Every state has a formal way of how a will should be drafted and executed. Most states also allow handwritten wills. I always recommend doing the will the proper way, but I know that's not always not always possible. So if you have to do a handwritten will, have a family member that needs to do a handwritten will, the law says that that will must be totally in that person's handwriting and signed and dated by them. I've had clients to come in with what we call the holographic will. That's a handwritten will, which their family member typed the will up and then signed it, but it's not admitted, or it's not able to be admitted to probate because it's not in the handwriting of the decedent, of the deceased person. So if your family member gives you a will that they've just kind of done on their own and it's typed and just signed, you need to let them know how you need to go back and write the whole thing in your handwriting. That's the only way it's going to be admitted to probate. Okay, and I've had a lot of wills that have been rejected and the property turns into heir property, and there may be 50, 60 heirs. And that's really becomes an issue for the one person that would have gotten that property. Okay, so intestate succession. So the second way that property is passed down is through heirship. And like I said, the state statute determines who your heirs are. The first line of heirship is your surviving spouse and children. Children includes biological children or adopted children. Adopted children can only inherit from their adopted parents. They can no longer inherit from biological parents if they have been legally adopted. Stepchildren are not considered heirs. Okay, children that you, nieces and nephews that you raised during birth are not heirs. unless you adopt them. So that's your first line of heirship. If you pass away and you have a spouse and children, those are your heirs. Spouses usually receive no less than 1/3 of your estate. And if you have children, your children would split the 2/3 that's left. If you don't have a spouse or children, then your parents. If you don't have any parents living, then your siblings. If you don't have siblings, your nieces and nephews, then your cousins. If you don't have any family or any heirs that can be located, then your estate goes to the state of Tennessee. Okay, and in order to for an heir to claim their inheritance, they must outlive the decedent for at least 120 hours. So sometimes you would see situations where a married couple would be in a car accident and one spouse may pass away and the other spouse will pass away shortly thereafter. If that second spouse does not outlive the first spouse for at least 120 hours, they're not considered the heir. Then of course, then it will go to the children. So when we have some situations like that, and a lot of times situations like that can be addressed in the last will and testament. And so having a will is very important, especially as to that aspect of it. If you do inherit property through the state statute, you need to file what's called affidavits of heirship. And affidavits of heirship is simply a notice that's filed with the registrar's office stating who the new owners of the property are. And there's no need to probate or file anything through probate. Property that is not included in a will is what we call a non-probatable asset. And I should also probably make this caveat. If you have a will and you do not include your property in that will, and you don't have the necessary catch-all provisions in your will, and your family member goes to probate that will, if your property is not in there, it's considered a non-probatable asset and probate court will not address it. It goes straight to heirship. So make sure that if you acquire property after you do your will, make sure that you include your property in your will. You can update your will, you can amend it, you can add to it. Just make sure you include your property in your will, because if you don't, there's a good chance that probate court that's not our problem. You heirs, go to chancery court, fight it out, okay? And while property that's passed down through a will goes through probate court, property that goes through heirship goes to chancery court. Okay, so it's two different courts. And when you do file your affidavit of heirship, you also want to update. The Shelby County Assessor's Office with the death certificate so they can update their records as well.
So right now, we're going to open up the floor for the position of regional.
All right, rights of heirs of real property, who gets what? So when individual passes away and does not have a will, the spouse, as I stated before, and the children are the first line of heirship. The spouse gets at least 1/3, or what we call a child share of the estate. Okay, then the rest is split between the children, right? If there's no spouse and no children, then the other heirs that may be parents, aunts, uncles, nieces, nephews, whatever, then they split the interest equally. The only individual that gets a greater share than anybody else would be a spouse. They get at least 1/3. Now, Madam Governor brought up this topic of the spouse, a situation where the spouse was estranged, and when the gentleman passed away, she was very difficult to deal with. I've had situations like that myself, where I've had clients who remarried, actually. And this is a little bit different situation. I had a client who married a gentleman, and his wife of 30 plus years passed away from cancer. And of course, her name was on his house. And he remarried the individual that was my client, and he passed away suddenly from a heart attack. And of course, when he passed away, the children stepped in. This is my dad's house. We don't want you here. You need to leave. And she's like, well, wait a minute. We were married. This property is mine as well. Well, come to find out, the gentleman did not remove his deceased wife's name from the deed. So in essence, the house that she shared as her marital home with her husband went to his children. And of course, they kicked her out. And she was forced to find another place to stay, on top of the grief and, the mental anguish. She lost her home. She lost all of her, possessions that she had with her husband. And so it's very important that if you divorce, if you're estranged from your spouse, please, make an estate plan to devise your property to who you want it to go to. I know a lot of people that have been, I know a lot of people, but I've had clients who come to me for divorces. They've been like separated for 20 or 15 years. And it just amazes me. It's kind of like, what are you thinking about? But that's kind of, you put yourself and your loved ones in a very difficult situation when you have someone else that has so much power over your belongings, over your estate, and even over your health, because your spouse is your next of kin. And, I'm kind of caveating off the real estate, but if you are terminally ill, you have a heart attack, you're incapacitated, your spouse that you've been estranged from for 20 years get to make decisions for you. If you are estranged, if you're divorced, please make sure your personal documents are updated. Make sure you have a will and you're giving power to people that you that deserve to have power. The rights of the heirs of real property. All heirs are needed to transfer 100% of the property. So one person cannot sell the property, one person can't dispose of the property. In order to transfer 100% of the property, all the heirs have to be in agreement and sign off. Any individual heir can transfer his or her own interest to whomever they choose. So you could find yourself owning the property with a stranger. Any heir can reside in the property, as Madam Governor stated in her presentation. We discussed siblings who move in, they don't want to move out, they don't want to pay any taxes, pay for any maintenance or upkeep. And that causes a problem because all heirs have an equal obligation to expenses, debts, and upkeep of the property. So property taxes are going to keep going. The mortgage is going to keep rolling. The city is going to want you to comply with the upkeep of the property ordinances to keep the property in a condition that's that won't cause a nuisance to the neighborhood. And so those things everybody is obligated for when you're an heir of a property. And when you have one individual that moves in, refuses to do anything, it causes a problem. And lastly, all heirs have equal rights to income made from the property. So if you decide to rent the family house out and you're paying all the taxes, you're paying for the upkeep, and you're renting the house out and you have this little bit extra coming in, And here comes the sister and brothers and say, hey, well, half of that money is mine, you know, that causes a problem because in essence, you are supposed to equally share the income, but also equally share the debts and expenses. And that's where a lot of issues with heir property come in, is that one person is living in the house and everybody else is maintaining the upkeep of the house or the property. Now we're going to discuss common issues with heir property as it relates to the execution of wills. And as I stated before, when you have a will, you want to make sure that it's properly executed, that it's complying with the Tennessee statutes as it relates to last will and testaments. I've had a lot of issues with lost wills. If your grandmother had a will and nobody can find it, but you have a copy can be admitted to probate. However, there are extra hoops that you have to jump through. So if you know grandma is ill, she's losing her memory, she may be diagnosed with a terminal illness, you need to make sure that you know where her important documents are, what attorney she used maybe to draw up those documents, if they need to be re-executed, have all those things in order. Also, wills can be contested. If you have a contested will, that could be quite litigious and it carries out and it can be very expensive. I have a case right now where my client's mother has passed and he has 2 siblings who are living in the home. And he filed some legal action because they didn't want to cooperate with him as it relates to the house. And one sister has presented a will, another sister has presented a different will. And my client is like, well, wait, what will? I know there was a will. So you have one person that didn't know there was a will, and then 2 different individuals, 2 different wills. And so as you can imagine, that's going to be probably end up being a very expensive and drawn out process to figure out how to resolve these issues. So when you do have your will drawn up, make sure that you have the appropriate clauses in your will to discourage people from contesting your will. Make sure you give copies to a lawyer, make sure your family knows where your wills are. So at the appropriate time, your appropriate last will and testament can be probated. Madam Governor also touched on this: property sold prior to the death of the owner. Well, I think there was a question about this. If you have a property in a last will and testament, however, at the time of that individual's death, they had already conveyed the property to someone else. At that point, the property is no longer considered a part of the estate. And, some people are surprised by this when they probate their parents' will or aunt or whoever, sister, brother. They are sometimes surprised that the property has been sold. So you want to make sure you have those conversations with your family members and update your will as needed. Another common issue is minor beneficiaries. And this is very important. If you have minor children and you put them in your will, the probate court will have to step in and monitor the estate of that minor and appoint a guardian over that minor's interest. So if you have minor children, I always prefer trust, because trusts do not go through probate. You set up a trustee. However, if there is a minor in a will and that will contains real estate the minor may be entitled to, a guardian would have to be appointed for that minor. So a guardian, what's called a guardianship, would need to be open, which is a totally different process. And it's just as expensive. The court will monitor that minor's property until they're 18, 21, and sometimes older, depending on what's going on. And in order to access any money, get court approval to sell that property, you have to have a court order. So if you have a real property and a minor is the heir, you have to go to court, even if it's not in a will. You know, it could be passed down through heirship and there'd be a minor heir. You have to go to court, get court approval to sell the property. And the court is going to want to see an appraisal. They're going to want to see a contract. They're going to make sure the property is being sold for fair market value. And so I often try to counsel my clients to make provisions for minors that keep them out of probate court. But if you do find yourself being an heir with a minor, just keep in mind that you will have to go to probate court to do anything with that property. Or if you have clients or someone that's trying to sell their property and there's a minor heir, they're going to have to go to probate court to do anything with that property. So we're going to talk about now issues with intestate estates, and that's estates that pass down through heirship. So I have quite a few clients who come in with issues of legitimation. Well, this was my dad, but he's not on my birth certificate. And so when he died, they left me off the affidavit of heirs. Or there's an adopted child with no record of the adoption. Adoption documents are sealed. And so you have to go through a process to get those documents. So if you have legitimacy issues and you don't have a birth certificate, you're probably going to end up in court trying to prove that you have some ownership in the property. Another common issue is improperly filed affidavits of heirs and deeds, which are going to require legal action to correct impossible adverse possession issues. If you have a family member that conveyed the property to someone else and they didn't have the right to convey that property, if it's that mom and dad's old house and they sold it to the lady across the street, decided to move in the house. She's been there for 7+ years. And then you realize, oh no, that shouldn't happen, and you try to stop it. Well, she can claim adverse possession to that property, which means that by nature of her living in the property for so long, having a defective title, paying property taxes, keeping up the property as if it was her own, then she may have a right to keep that property. So it's I often try to counsel my clients around tax time. Look at your estate planning documents, go and look at your deeds to make sure nobody has changed anything or filed anything inappropriate or clouded your title to the property that you may have ownership in. The biggest issue is disagreement between heirs, which we've talked a lot about, the payment of expenses, the rights to reside in the property, the rights to earn income on the property. We often have issues locating heirs. I have clients now that I'm dealing with trying to find heirs. They can't do anything with the property, absent going to court to do anything with it. It's heir property. They don't have to go to probate if they can find the other heirs to try to liquidate the property. However, without finding those heirs, there's nothing they can really do with it. So now they have to consider spending money to go to court or just letting the property go in a tax bill or something. Again, we talked about minor heirs. That becomes an issue. We also discussed estranged spouses and the issues with estranged spouses. Resolving heir property issues. There are several ways that you can resolve your issues if you're having property issues with other heirs. One is to discuss a buyout. If you all can attend mediation, discuss appropriate ways to buy one another out, buy out the other heirs. A lot of people, I tell, money talks. So if you offer a good enough, if you offer a good enough buyout, they may say, okay, I'll sign off, and then you can move on with whatever you want to do with your property. Transferring the interest in the property. I work with some families that are amenable and reasonable, and they're, hey, I don't want it. I don't want to pay taxes on it. You can have it. Where do I sign? And doing just an agreement to sell the property and split the proceeds. The other option is litigation. Normally other than probate, there are two types of litigation that heirs would normally enter into when they have property issues. One is a partition and the other one is called quiet title. So what happens in litigation? When you file an action to partition property, this is probably the number one issue that legal filings that I do with heir property are partitions. And that's when one property owner no longer wants to be obligated to own the property, the real property. And the Tennessee law says that even out of 100 heirs or 100 property owners, if one owner no longer wants to be obligated, they do not have to be obligated. All they have to do is go to the court and say, hey, I want court order to sell this property. Okay, the other 99 heirs will have to either buy that one person out or be subject to the sale. Okay, and so that's the number one legal issue that I normally encounter with heir property, when people can't agree. One owners just say, hey, let's just sell. Most times, like I said, it's mom and dad's house. There are one person that wants it sold, the other people don't want it sold, but nobody wants to buy them out. Nobody wants to be responsible for it. And, it just ends up going into a forced sale or a tax sale. The options during in a partition action is, like I said, to offer to buy out. If you cannot afford to buy the other individual out, the court will force a sale on the property. That means that one individual can stick a for sale sign in the yard and sell it, hopefully for fair market value. And then the proceeds would have to be split amongst all of the heirs equally, or according to their interest in the property. The person filing the partition can also ask for attorney's fees, court costs. They can ask for expenses back off what they spend on the property. That would be taken from the amount that each heir should have been contributing towards expenses. I have a really interesting case now where my client had his sisters and brothers to sign off on a quitclaim deed, quitclaiming the father's property to him, in which he in turn tried to sell. Well, one of the family members hired a lawyer and said, hey, I didn't know that that's what we were doing. I didn't tell him to sign my name on that deed. Plus the affidavits he filed were not accurate. Well, come to find out, there was a deceased brother who had 6 children. One of the 6 children was deceased who had a minor child. So you probably can imagine how that turned out. We had to reverse everything. And my client now is seeking to file a partition for the property, and he paid off about $86,000 in mortgage, in a mortgage on the property. So he's asking for $86,000 plus all the upkeep and property taxes he spent out on the property. And so the property is not even worth what he spent in it. But if the court orders to sell and he asks for his expenses back, those expenses are going to be divvied up between each heir. And there's going to be a judgment for expenses. And so things like this can go downhill real fast and get real ugly. And what's probably going to happen in this case is that these other heirs are probably going to end up owing above and beyond whatever their interest even is in the property in a judgment. And there is a 2-year-old that's also in this situation as well. And so there's going to have to be a guardianship set up for that 2-year-old. So this is probably going to be an issue that's going to be long, drawn out, and expensive. And what dad could have done was just gotten the will and say, hey, this is how I want my children to share this property. The second most common real estate litigation issue I have is quiet title. We've filed petitions to quiet title, usually to remove clouds from a title, from improperly filed deeds or affidavit of heirs. And we're asking the court to restore the property rights to the rightful owners. So if there is a client who was left off of an affidavit or had a sibling that quit claim the house to themselves or to someone else, or if people are in the business now just stealing property, we deal with that a lot too. Or if you happen to be searching, looking at your titles, and Joe Blow has quit claimed his property to him, your property to himself. I've had that happen too. We need to immediately file a quiet title in Chancery Court, and partitions are filed in Chancery Court as well. And then the last one is adverse possession. And I think this is important because I've had these cases too, where one family member transferred title to just an individual, a stranger, and that stranger thought they had clear title, lived in the property for 7 years, and then the other heirs realized it 10 years later, but the individual that's living there has a claim for adverse possession, which means that they could claim that the property is theirs and the court will grant it to them because of Tennessee laws do honor possession of property, what we call hostile outright possession, for 7+ years if you have a defective deed. So just keep that in mind too, especially agents who deal with a lot with their property. If you have clients that, say, hey, I want to sell this property, and then you get the deed and it's been over 10 years and somebody's living there, there might be an issue with them even being able to regain title to that property. So lastly, there are other estate plan options for real property, and Madam Governor touched on trust. We highly recommend those to avoid probate. If you have minors, if you have a lot of property, if you have a specific way you want your property to be liquidated and distributed to the beneficiaries, a trust is the way to go. Trust must be funded, which means that the property must be conveyed to the trust in order to be controlled by the trustee. Also, conveying property prior to death. Madam Governor talked about life estates. You also want to, I strongly recommend, if you do include someone else on your title, that you do so with joint rights of survivalship. I've had situations where 3 people were on the title, but it was not specifically stated joint rights of survivalship, and with one person died, and then they had like 10 heirs and now they own the property with 10 other people they never intended on owning property with, and sometimes they include minor children. So you want to be sure that if you do put other people on your deed, whether it's your children, parents, whoever, make sure you understand the ramifications of that. Also, beware of liens. If you own property with your siblings and somebody gets a judgment, somebody has a personal injury lawsuit, someone has a tax lien, IRS lien, it's going to cloud your title. And until that lien is paid, you're not going to be able to do anything with that property. All right, and lastly, real property tax consequences. I kind of touched on this earlier. If you have a tax incentive, as far as real property tax is concerned, you want to be sure that adding another individual on your deed is not going to affect your eligibility to continue with the tax incentives that you may be getting for your real property taxes. That's the last slide that I have. If anyone has any questions, this is my contact information. Actually, I transposed my telephone number. It's 472-0010, not 11. And this is my website. If anybody has any questions regarding real estate issues, probate issues on the legal side, feel free to reach out to me. And I'll, answer your questions as best as I can. And if anybody has any questions about any materials that I just went over, just feel free to put it in the chat and I'll try to answer them. And that concludes my my presentation. You're muted. You're muted, Madam President.
Now, thank you for letting me know that. Thank you so much, Attorney Bostick. She's our parliamentarian, guys, for the Women's Council, for such wonderful information. I thank our Madam Governor, Nedra Redditt, as well, for bringing us such a plethora of news that we can use, guys, to keep our families in line, to keep those relationships strong amongst our family members when we pass on, and really help us to outline the things that we need to do in order to secure a success, a positive succession of where our heir properties should go in the event of our untimely passing or our elderly passing, what have you. As stated before, Attorney Bostick's information is up on the screen, I believe. Still, I think I still have control of it, but her information is there for us to see. And of course, you can reach out to Madam Governor by going to the Women's Council website. You can go to her website. She is the instructor and principal broker for the Redditt Team Realtors and Pro Real Estate School. And if we don't have any questions, we'd like to conclude. So let me ask our guest set, are there any questions that we want to ask Ms. Bostick or Madam Governor before we conclude our programming for this afternoon? Okay, good. Well, when there's no questions, I feel like we've done our jobs, guys. So with that being said, I would like to thank everybody for joining us today. I'm not sure if our first VP is still on the line. I would love for her to pray us out since she prayed us in. And then we look forward to seeing you guys at the next event. I believe that is going to be on Monday at 12 p.m. Make sure you go to www.WCNMemphis.com to find out about those upcoming events and to join us. It is a $50 annual investment. It's an investment in your existing life. It's an investment in your future. It's an investment in your career. It's an investment towards building financial wealth for your family. So I don't think she's still on here. I don't see her, so she probably had to step off. So I will go ahead and pray us out. And so if everybody will just bow their heads for a few minutes, please. I'd like to thank our Lord and Savior, Jesus Christ, for bringing us here all together today to partake in such a wonderful wealth of information that we can use to keep our families stronger, to build stronger communities. Thank you for giving us the tools necessary to share this information with the community. And I pray, Father, that you allow this information to be carried as far as we can get it, so that people can learn, be enlightened, and put this information into action to improve their lives. These things I pray in Jesus' name. Thank you. And with that being said, guys, have a good day. Thank you for joining us. And again, don't forget to go to WCNMemphis.com to register to be a member and to register for our upcoming events. We have about 2 weeks worth of wonderful things left to share with you for this month. So take care, everybody.